part of Sul Lee Law Firm. My name's Allison Gilland. I am an associate attorney.
I'm Darren Singh. I'm the managing attorney here.
I'm Stanford Holmes. I'm a senior counsel.
And we all have different backgrounds. And what we're talking about today with the legal gray areas of using AI tools. So we all present a different base from our own experiences and also like keeping up with current knowledge.
Oh, we're talking about AI law.
Yes.
Yeah. My background, I used to work in the tech industry, and so I did a lot of 2D and 3D computer-aided design. So that's why I tend to have more of a technical outlook of what's going on.
My technical background's from much longer ago. It's the late 90s. I was involved in a .com startup that had a lot to do with developing proprietary technology in the oil and gas space.
So I really enjoy working with companies that are on the forefront, and sometimes mistakes are made, and that's when we get to do some litigation. But I'm really excited to see people that are working with new and exciting things.
I think a lot of it has to come with businesses not understanding how AI works, how it takes materials, how it's able to share, really the protections you need in place, but I think also just understanding how the law wraps around it as it's replacing some jobs that would fall into things like copyright and trademark, and there's a lot of things that have gone through the processes of those that AI, now you're having any person being able to walk in and take a position in these fields without understanding what's behind the law of it.
I think from the perspective of a business owner or someone who's launching a new company, one of the things to think about when you're talking about AI is the exclusive rights you have, the right to prevent others from doing the same thing you're doing. And if you get to a conclusion using AI, someone else is able to get to that same conclusion using similar prompts. To what extent can you foreclose them from using the same product that you came up with? That's really the core issue. And as Allison was mentioning, it breaks down into fundamentally copyright questions and trademark questions. Those are very different regimes under the law, and they have different consequences.
Yeah, and I think that's a really good way of looking at it. I guess I look at it, if you are starting a new business, or you have a new one or whatever, you really are trying to answer this question in the short term in our future. It's what value did you bring? What value did your company bring? And then once you brought that value, how are you protecting it? Protecting it both from other companies, but from someone who just says, look, I can do this myself. And so those are the two kind of different ways they're talking about it that Darren just referred to.
No, I agree with that because I do find a lot of people, especially in the creative field, there is this line of understanding what exactly is value in the eyes of law. Like you have product, you have ideas, and you have things that you think are unique to what you do, and you're now using these tools to create them. But those tools have their own autonomy, so they're almost on their own without you having to do much to get results. And so that's where a lot of this breaks down into.
Yeah, it's a good question. So I think the first thing to focus on is what does copyright fundamentally protect? And copyright protects fundamentally original works of authorship. But the idea is that it's original authorship. The way the law reads right now, if it's 100% machine derived, it doesn't have a human author. And so it can't be protected. Is fundamentally the court saying no to AI.
Similarly, the focus is really, and that goes into understanding what is AI, what is machine learning, and at what point is the human input enough to be copyright.
And I think there's even beyond that, there's the question, even if you have or you own the AI that's being used, partially we're still figuring out how all this works, what's going on in the black box. But that fact means it's hard for you to say, hey, I just used a tool. Again, I always come back to this element of like, what value did you personally put into this? And prompts.
Yeah, and that fits into the framework for copyright because it's fundamentally original authorship. The authorship question really asks the human question. Is it a machine, a monkey, or a person? The originality gets to this idea of value. He did a good job with it in the past. So those lines have been dealt with before in the past, and that goes to that originality issue when you're dealing with machines, the interface of humans and machines.
Yeah. So to bring this more outside of just talking largely to things that actually exist that may be more commonly known by people trying to use AI right now, we talk a lot about the creative field when we do this. So for example, like there's a lot of tools that have AI to it, and then they also have the more advanced ones. So it's to what extent is the tool doing all the work for you? And I kind of liken this to working in graphic design, where it's kind of what instructions are you giving is what they've been looking at. And if you're one of those people who walks into the office and you look a graphic designer dead in the eye and you say something along the lines of, hey,
Get back to work.
yeah, exactly. They're like, hey, you didn't give me what I wanted. For example, like we would have people come in and they'd be like, hey, I really want an image that represents like kind of hippie youth spirit. Here's our company colors. Like, can you get me a couple designs? That's not copyrightable at all because you just gave general instructions. And so that's why the Copyright Office has come out and says that prompts itself are not enough. You have to show like how you directed it to reach the final result. So, for example, we have a lot of tools. I think a large one that you have mentioned, our marketing's definitely played with, is Midjourney, which you'll put in prompts and it'll generate the full image. And that is basically machine driven. Like the prompt, they can do edits, you can direct it in different directions, but for a large part, you're not really controlling it. And there's not predictability. That might look like something that you want, but you didn't have a clear image when you started likely. Where you have other tools, like with Photoshop, with generated by AI and Photoshop, this kind of goes back to also like copyright and photograph. This has been like a long-standing discussion, like how much editing in Photoshop is allowed and things like that. With Photoshop, you can select maybe like a small section. So you'll like highlight a tree and you're like, I really don't like that tree. Can you put that in there? And that's just one small part of the image. That's you using AI to edit and change with direct control, and it doesn't always change the general purpose or theme, and that's something that's more directed. So I haven't really seen anything personally on this yet, but I do think if you're talking about using AI in that sense, I do think there's a level of human authorship that could be argued.
So from a practical perspective, if you're a business and you're looking at asking whether or not you can get copyright protection for something for which there's a machine component, it sounds like what you're saying is the extent to which you've got more precise and hands-on directives to the machines, the more you're increasing your chances of ending up with something that's a protectable work of copyright. Is that right?
Yeah, I think that really goes into at what point they will consider that your instructions created this result.
And this doesn't really just stop at creating graphics or that type of thing. I mean, you could be you're thinking about your policies, for example, dealing with people in the HR realm or something like that. Increasingly, people are coming with different AI tools to figure X or Y out. I think part of the bottom line is if you don't understand what it is using, what it is doing, and I think one of the other important things to learn as an extension of working with AI is, to whatever extent possible, you need to understand what's going on in the background. And if you can't personally, in the background, the black box, what I call it, if you can't do that though, show your work, like back in school. Show where you added to this policy and approved to whatever about this policy and it made sense to you. Because you can still be liable for tools, quote unquote, that you used that have a disparate effect. So sorry to veer that away from graphics, but it's also relevant.
Actually, something more recent I've noticed in updates to a lot of these AI tools is they let you export pretty much the entire prompts now, because the Copyright Office does seem to be leading this to the courts.
Which is a great point, but I mean, just like you said, your prompt and all the things even that got you there is different from knowing what it actually did in the background. You don't necessarily know what the AI trained on, or what their sources were, or even from case to case or request to request, exactly what similarities it's seeing. And that's one of the elements of having a large language model, which is largely what we're talking about here. And so yeah, even if you have those to save and download, we definitely recommend that. Lawyers like to always keep more records, but I think you still need to pay attention. If you can't know what's in that black box, you need to know what exactly you added on top of this to make it yours.
There's another layer, and you guys mentioned this idea of the machine taking into account what you're saying. So now your prompts are something the machine now knows about. Your output is something the machine has a record of. So it's getting feedback from you In other words, if I ask it the same questions after you've asked it a question, it's going to come to a different conclusion because it has the benefit of what you've already gone through, right? So there's a feedback system to it. You're changing where the bar is, you're changing the state of the art just by you asking it that question. So one thing, this is maybe a little bit tangential, that you have to be careful with in the legal space is, are you giving up confidential information to a publicly accessible machine when you put that stuff in there? That's one thing to be concerned about. But from a broader perspective, what we're talking about is the machine's constantly changing. It's constantly learning. And so just because something was novel last week and an original work of authorship last week, it doesn't follow that it will be this week because the bar's moved. So I know we've been talking about this in terms of copyright. To some extent, this starts to fold in patent concepts like state of the art. The state of the art is constantly moving, and it's being affected by the people who are using the tool. Something to be aware of because things change.
And I also say a lot of these tools, a lot of the ones that we talk about are the ones that are public platformed. You have free trial use. There are a lot of companies who are developing their own AI systems to keep it more centered and more private. But you do see that because this is being left to the courts, every decision that comes out is drastically changing how those companies are utilizing AI. For example, you can choose to believe ChatGPT's answer that it gave you, and it does kind of show that, they are considering what can, as decisions come out, the machines themselves are changing as well.